So my court case is Brandenburg versus Ohio. It's about Brandenburg, a KKK leader who made a speech at a Klan rally and was later convicted under the Ohio criminal syndicalism law. So Clarence Brandenburg is a KKK leader in rural Ohio, and he contacted a reporter at a Cincinnati television station and invited him to cover a KKK rally that would take place the summer of 1964. So the rally was filmed, and it shows men in robes and some in hoods, and they were carrying firearms, well, most of them. And they first burned a cross, and then later moved on to make speeches. One speech claimed that our president, our Congress, our Supreme Court continues to suppress the white Caucasian race. And then this was a speech by Clarence Brandenburg, and then he announced plans for a march to take place in Washington, D.C. on the 4th of July. So Clarence Brandenburg was convicted. He was charged with advocating violence under the Ohio criminal syndicalism statute for his participation in the rally and the speech. The statute forbids advocating violence, sabotage terrorism as a means of accomplishing political or industrial reform. He went against the statute because his speech called for revenge against the government, and he was also charged with the second count for voluntarily assembling a group to advocate syndicalism. He was convicted in the Court of Common Pleas in Hamilton County, and he was fined $1,000 and sentenced to 1 to 2 years in prison. He challenged the constitutionality of the criminal syndicalism statute under the 1st and 14th Amendments of the U.S. Constitution. The Appellate Court of Ohio affirmed his conviction without opinion and rejected his claim that it violated his rights. So the issue at hand is, did the statute prohibiting public speech that advocated certain violent activities violate the defendant's rights to free speech under the 1st and 14th Amendment? And the ultimate decision was that yes, it did. The U.S. Supreme Court reversed his conviction, holding that government cannot punish abstract advocacy or force of law violation. And this decision was reached per curiam opinion, and per curiam is the ruling issued by multiple justices in which decision rendered is made by the court acting collectively. And it overruled the Ohio criminal syndicalism statute and the court case Whitney versus California. The Syndicalism Act properly made it illegal to advocate or teach doctrines of violence, but it did not address the issue of whether such advocacy or teaching would actually innate imminent lawlessness. So basically they're saying that abstract teaching of the need to resort to violence is not the same thing as preparing for violent action. And this whole Supreme Court case led to the imminent lawless action test, or also known as the Brandenburg test, for judging what was then referred to as seditious speech under the First Amendment. There's 3 elements which they test for: intent, imminence, and likelihood. A concurrence was issued by Justices Hugo Black and William O. Douglas. They basically said that a clear and present danger doctrine should have no place in the interpretation of the First Amendment. And here's a quote by Douglas. He says, "It is disconcerting. Threats to which it has applied were allowed impunity, and the test was so perverted in intentness as to make trial of those teachers of Marxism and not allow political trial, which was part and parcel of the Cold War, that has eroded substantial parts of the First Amendment." And then here, that's Justice Hugo Black. Surprisingly, he was part of the KKK, but he later admitted it was a mistake. And that was Justice Douglas, and he was a strong advocate of First Right amendments. So as mentioned before, Brandenburg versus Ohio overruled Whitney versus California, and it cast down other cases, some of them being Schmeck versus United States, Dennis versus United States, and Abrams versus United States. Also, this court case made sure to distinguish between violent acts and hateful speech that implied violence. So since 1969, court decisions have been consistent with Brandenburg. Flag burning attempts were struck down as violations against the First Amendment and other kind of things. It's also the last major statement on what government may do about inflammatory speech that seeks to incite others to lawless action. And then the next slide is my works cited.
All right, thank you.